started on. Okay, well, we'll go ahead and get started. It looks like we have about 16 attendees in the webinar. So I'll make sure that we have this presentation up. All right, good morning, everyone. My name is Chelsea Hayman. I'm from the Maryland Department of Disabilities. This is our final webinar in the Tenant Training Train the Trainer series that we've been doing with people who are supporting 811 and Weinberg participants as they move into their new units in the community. So thank you to all of you who have stuck with us over these last couple of weeks. I hope that this information is informative and helpful for you as you assist individuals with moving into the community. This morning, we have our special guest, Luciene Parsley from Disability Rights Maryland, who will be co-presenting with me on understanding reasonable accommodations and modifications. This presentation, as you may have heard me in the beginning mention, we have conducted this a couple times. There is a recording of this presentation or a similar format of it on our YouTube page, but I will also upload today's presentation to the YouTube as well for those of you who want to refer back to it. As you might already be able to tell, everyone is on mute. What I will do is, if you want to use the raise your hand feature in Zoom, you can do that, and I will go ahead and, my apologies, let me run the live transcript. Okay, so I have the live transcript going now. If you need that feature, it should be showing up at the bottom of your screen right now. And if for some reason it is not, just raise your hand and let me know. You can put that in the chat and send it to me as a direct message, and I'll be able to see that. For those of you who are joining us, I want participants to use the Q&A feature for any content related questions as we go through the presentation. And if you have general comments or feedback, please go ahead and use the chat feature. Also, if you have a technical issue for some reason, please use the chat feature, not the Q&A feature. I will generally be monitoring both during the course of this presentation, so that way everyone gets all of their questions or concerns addressed. So I will go ahead and get started. Okay. All right, so this is just a slide to go over the agencies that are part of the Maryland Partnership for Affordable Housing, or MPA, as we refer to, the acronym we refer to for this collective of organizations that fall under the umbrella, working on our housing programs in collaboration with the Department of Disabilities. Okay, Luciene, I'll let you take the slide.
Good morning, everybody. Hi, I'm Luciene Parsley. I'm the legal director at Disability Rights Maryland. On your screen is what we are all about. I think most of you probably know what we're all about. We're the Protection and Advocacy Center for Persons with Disabilities. We offer free legal assistance to people with disabilities in a whole variety of areas. You are welcome to call us for technical assistance, refer your clients to us, etc. Chelsea, should we jump in it before we get to the content? Do we want to do the pre-test?
Yes, I will go ahead and launch a poll now. So for those of you who are joining our webinar via computer, you're going to be able to see a poll, and this will be our participant pre-test for today's presentation. So go ahead and answer the questions. There should be a total of 8 questions to the best of your ability. And you'll have about, I'll give you a couple minutes to go through those and answer some of them.
And we're going to go through the answers at the end. So this will hopefully highlight you to topics that you have questions about as we go along.
Are you all able to see the poll? I don't see any answers coming in. Okay, here we go. I'm getting some answers. Okay. Make sure all right. I'm going to end the poll in 10 seconds here. So make sure you get your answers in. Okay, very good.
Okay.
All right.
Next slide, please.
Mm-hmm.
Oh, here, great.
Yeah. Okay.
Okay, great. I'm gonna close it. Okay, so here's what we're gonna do. We're gonna fly through the beginning part of this training, and we are going to omit a break. I know many of you have had this training before. We are going to try to concentrate a lot on thinking through reasonable accommodations and common barriers and how to address them. We're going to also do some skills work and group work at the end of this. So the first part will go pretty quickly. I encourage you to put your Q&As in as we go along. I'll try to address those since I know some of the legal work will be, the legal content will be reviewed. So next slide. Okay. All right. So we offer this training with the Department of Disabilities and MPOD because it really addresses a fundamental issue of obtaining and maintaining housing for people. It addresses that history of segregation and stereotyping we all know about, and really helps people to maintain stability and have a better quality of life. So next slide. Okay, so as we're talking about housing and fair housing for people with disabilities, it's really important to understand who we are talking about. We're talking about the legal definition, one or more physical or mental impairments that substantially limit one or more major life activities. So a person who has a physical or mental impairment, at least one, that substantially limits one or more major life activities, in some contexts has a record of such impairment or regarded or is related to someone, is somehow connected to someone who has that disability. You do not have to be found to be a person with disabilities by the Social Security Administration. You don't have to have benefits yet. You really just need to have a medical professional verify that the individual meets the definition under the Fair Housing Act or the Americans with Disabilities Act. It can be a social worker, a case manager, etc. The Fair Housing Act currently exempts from definition those whose sole disability is current addiction to illegal drugs. Next slide. Okay, so we're going to kind of go through a couple of terms so we're all on the same wavelength with understanding what I'm talking about. So reasonable accommodation is a major thing to know about when you are dealing with housing for people with disabilities. And what I mean when I talk about a reasonable accommodation is a change in rules, policies, practices, services, giving the person with a disability equal opportunity to use and enjoy a dwelling unit, a common space, and it can be applied to programs as well. They can be necessary at all stages. So application stage all the way through to eviction. Next slide. Okay, so reasonable accommodations are required by our civil rights laws, our federal laws and state laws that mandate fair housing for people with disabilities. They first and foremost prohibit housing discrimination against qualified persons with disabilities and say you can't treat someone less favorably because of a disability. They require a provider to do more. So that is a little bit different from some of our other civil rights laws, for example, the Civil Rights Act, because they actually require affirmative action. They require a housing provider to actually make changes in rules and policies and procedures, practices, et cetera, if necessary to afford the person equal opportunity. So for example, might require a landlord to permit a change in how the tenant pays rent, even if that's not their current policy. May allow an applicant to demonstrate that they can meet the requirement to comply with a lease in a different way. The important thing to know, and you'll hear me say this several times, is there must be a connection or a nexus between the accommodation that is requested and the person's disability. Next. Okay, reasonable modifications. I kind of think about this as a subset of reasonable accommodations, but a modification is a physical alteration to the existing premises. For example, a grab bar, a ramp, widening a doorway, etc. Next slide. All right, so we're gonna briefly go through 5 laws that protect people in housing. First is the Federal Fair Housing Act, which was passed in 1991. Maryland similarly has a Fair Housing Act that expands a little bit on the Fair Housing Act. We also have an accessibility code, which governs how housing is built and maintained. We have Section 504 of the Rehab Act of 1973 that covers housing receiving federal funding directly. And we have the ADA, the Americans with Disabilities Act, of which Title II and III have some application to housing, even though the ADA does not specifically apply to housing. Title II, which covers government operations, does cover, it has been extended to cover housing funded by state or local government. And Title III covers places of public accommodation like leasing offices or gyms or swimming pools, other places of public accommodation that might exist at a housing provider. Next slide. Okay, so we're going to jump into the Fair Housing Act. The Fair Housing Act was enacted as Title VIII of the Civil Rights Act of 1968 and amended in 1988. I'm sorry, I think I previously said the wrong date. In 1988 to prohibit disability discrimination in housing. So it was an amendment to the original Fair Housing Act that included people with disabilities in there starting in 1988, pretty recently. Applies to most housing, private, subsidized, includes condominiums and housing HOAs. Lots of times HOAs and condominiums tell me that they don't believe they're covered by the Fair Housing Act. In fact, they are. It does prohibit discrimination in sale, rental, or conditions of housing, application, screening phase, tenancy, or eviction. It also, as we talked about previously, requires reasonable accommodations and a minimum level of physical accessibility. Next slide. So there are some exemptions to the Fair Housing Act when it does not apply. For example, single-family housing. Sold or rented without the use of a real estate broker, pretty unlikely in our day and age. Housing operated by organizations and private clubs, and this is the important thing to know, that limit occupancy to members, pretty unlikely. Housing legitimately restricted to seniors 62 and older or 55 and older. And what I mean by that is that providers that offer housing that is built and constructed to apply to seniors 62 and older, or 80% of their have a rule restricting their housing to 55 and older, that is not considered discrimination under amendments to federal law. Also, owner occupied buildings with 4 or fewer units, called the Mrs. Murphy exception, are exempted and are not covered by the Fair Housing Act. All right, next slide. Okay, so under the Fair Housing Act, some of these will be fairly obvious. You cannot, a landlord or housing provider cannot refuse to sell or rent to someone who has a disability, cannot make housing unavailable or say, we don't have that unit anymore, take it off the market, cannot advertise housing as available only to people without disabilities or those who can live independently, cannot discriminate in terms, conditions, privileges in sale or rental. So sometimes we'll see a requirement for additional insurance, for example, for someone with a disability. Refuse to make reasonable accommodations, which must be specifically requested. Can't refuse to permit reasonable modifications, changes to the unit at the tenant's expense. Cannot threaten, coerce, or retaliate against anyone for exercising a fair housing right. So this is almost all housing built today. And specifically for housing that is, there are different rules, we'll say, for housing that has a federal or a federal subsidy in it. Okay, next slide. All right, so modifications. We talked about accommodations. Now we have reasonable modifications, or that's the making of changes to the house like ramps or grad bars. Generally speaking, the tenant is responsible for making and paying for those modifications. Again, there's different rules for federally subsidized housing. If the development, however, was already required to have been made accessible, for example, it was built or renovated and not made accessible, or there's federal funding involved, then the tenant does not have to pay for those modifications. The Fair Housing Act does have a provision which says that the tenant may be responsible for restoring or paying to make the unit back to its original condition when they move out. HUD has said that should only apply when the changes impact the marketability of the unit. Next slide. Chelsea, can you do the next slide?
Oh, I thought I had.
Oh, wait, maybe it did go. Oh, yeah. Oh,
Yeah.
I think
Okay.
it did. Okay. Generally, restoration is not required. So this is kind of building on my last comment. If widening doorways, grab bars, installing accessible routes, tenants, and the reason for that is it doesn't matter to the next renter. Those generally would not even be noticed. And if they were, they probably would be seen as a benefit. Under the Fair Housing Act, tenants are permitted to make modifications to common areas like lobbies, if needed. A landlord may require approval of plans in a contractor, but cannot require a more expensive modification. And the landlord must maintain the modification once the tenant installs it. Okay. I guess can you go back a little bit, Chelsea, one, because I didn't say this, that modifications that are only used by the tenant would be responsible for maintaining. Okay, go 2 up, please. Great, thank you. Okay, so we've talked about this before. These are examples of modifications. Next slide. All right, so how do we pay for modifications? There's a variety of ways. It's not always the simplest thing to do, but Medicaid waivers, some of our Medicaid waivers do provide for accessibility modifications. There are local programs in several cities and jurisdictions. Baltimore County has something called HAMP. Baltimore City has something for HCVP participants. Some counties have local CDBG programs. The state does as well. That's that DHCD rehab program or accessibility for seniors program. DDA offers some funding. I think it's done on a lottery system for low intensity support services. And we do have a modifications directory that the Department of Disabilities has put together. In some rural areas, I've seen, Christmas, I don't know what it's called, Christmas in July or Habitat for Humanity have done some modifications as well for individuals. Next slide. Okay. So these are just some additional things we want you to know. HUD has said parking spaces, signs, restriping are considered accommodations, not modifications. Therefore, the landlord must pay. Generally speaking, case law has indicated that accommodations must be specifically requested, even if a provider knows about a need of an individual, they are not required to act on it unless it's been specifically requested. The individual making the request must need that accommodation due to their disability or that of a family member, and the accommodation must be necessary to afford equal opportunity or use of the housing. Housing provider must grant unless it's an undue financial or administrative burden. Okay, we're going to talk about what to do later if they do not. Okay. Okay. So what is a fundamental alteration or an undue burden? Fundamental alterations are determined on a case-by-case basis. A fundamental alteration is a change that is completely outside of what is the general business or purpose of the provider. An undue financial burden is cost that is excessive. It's must be an individualized determination for that individual. A housing provider cannot just say, you know, that seems too expensive for us. Even if the burden is met, the housing provider must continue to seek alternative accommodations to meet the person's needs. They're not completely relieved of their obligation. HUD has given this interesting example of a tenant who uses a wheelchair but can't use the dumpster in a complex to dispose of trash. The tenant requests that maintenance collect trash daily. HUD says maybe this is an undue burden for a small operation with just one janitor, but it might be reasonable to do so twice a week and or supply an inside trash unit to the person. Next slide. Okay, so Fair Housing Act, which units are covered? This is review. Multi-family complexes with 4 or more units in developments constructed for first occupancy after March 13th, 1991. All units in elevator buildings and ground floor units in non-elevator buildings must be made physically accessible. And we're going to talk about what exactly that means. Next slide. Okay, so when we're talking about the Fair Housing Accessibility Rules, there is a Fair Housing Act design manual. You'll get the link to this when Chelsea sends out this PowerPoint presentation, but we are talking about a minimal degree of accessibility. For example, not necessarily installed grab bars, but reinforced walls for grab bars to be added later, lowered controls within reach, like temperature controls, light switches, electrical outlets might be raised. Usable kitchens and bathrooms, meaning there's room for maneuvering with a wheelchair. Accessible routes without a barrier or steps throughout the building. Common areas such as laundry rooms, management offices, etc., all on accessible routes without barriers. Next slide. Okay, Maryland has a substantially equivalent Fair Housing Act. It does add a couple protected classes: sexual orientation, marital status, and gender identity. Although HUD is now interpreting the Federal Fair Housing Act to include sexual orientation and gender identity as well. We'll go to the next slide. Okay. So now we're going to move into federally subsidized complexes, and I think that is mostly what you all will be dealing with for individuals who are in 811 units or Weinberg units. Section 504 is a federal law that requires people with disabilities to not be discriminated against. So it's very, very short part of the law with regulations interpreting it. Says no individual with a disability shall be excluded from, denied the benefits of, or subjected to discrimination under any program or activity that receives federal funding. So what is required by the regs are reasonable accommodations similar to the Fair Housing Act, overall program accessibility, modifications paid for by the landlord, effective communication with people who have hearing or vision disabilities, effective communication with everybody, but there are specific rules for hearing and vision modifications and accessibility rules for new construction and alterations. Next slide. Okay, so when we talk about Section 504 covered properties, we are talking about public housing, project-based Section 8, project-based rental assistance, home funds, U.S. Rural Development Administration, USDA Rural Development Administration funded housing, Section 202. This is not any kind of complete list. There are many. We're not talking about tenant-based Section 8 or most low-income housing tax credits unless there is other federal funding in the project. In Maryland, actually, as of 2018, all by purposes of our QAP, all low-income housing tax credit units are covered by Section 504. Next slide. Okay, so accessibility requirements. This is physical accessibility. It requires a much greater degree of accessibility. 5% of units fully accessible to people using wheelchairs. It's usually termed UFAS. 2% of units set aside for people with hearing vision modifications, dispersal of units throughout, and other modifications to be made on request if the person needs something that UFAS doesn't already provide, or the person is not in a UFAS unit right now. So that might be things like changing the refrigerator out to a bottom freezer, side by side, grab bars at no charge to the tenant, none of this at charge to the tenant. Accessibility of non-housing facilities. So even if the development predates the implementation of Section 504, which is July 11th, 1988, and the building was built not accessible, the housing provider is required to make accessibility when it's renovated, and they have to make modifications to common areas and other areas upon request, as long as it does not pose a fundamental alteration or an undue financial burden. That's why it says may. Okay, next slide, please. All right, so here are some examples of undue financial and administrative burden. Sometimes people want things like walk-in showers, super helpful for people who want to roll into their shower. Sometimes we have high-rise buildings that have concrete floors that would require jackhammering the floor to put in a walk-in shower. Typically, those are considered to pose an undue financial burden to the building. It has been done. I'm not saying don't ask, but in existing subsidized housing units, a request for modifications to create a fully accessible new UFAS unit, if the unit already has 5% of its units compliant, that might be considered an undue financial or administrative burden. But of course, the person would still have the ability to request modifications for just those units they need, those modifications that they require in their house. They could also certainly request a transfer to a fully accessible unit. Request for programmatic changes outside the main business of the housing, for example, request to walk or care for service animals, usually a financial burden. HUD does consider the use of residual receipts to pay for alterations under Section 504. So you can certainly talk to a lawyer if a provider is telling you that it poses an undue financial burden to make the modifications that a person needs. Next slide. Okay, so there is an interactive process and obligation to affirmatively further fair housing under the Fair Housing Act. This means that a housing provider must continue to engage in negotiation to find a solution. If an accommodation cannot be granted, they can't just tell you, no, we can't do that, and be done with it. If there are several accommodations, the individual's preference should be accommodated unless it poses an undue financial and administrative burden. The housing provider may suggest alternatives. The person does not need to accept them. The PHA, the Public Housing Authority and recipients of federal funding do have a duty to do affirmative marketing and outreach to reach people with disabilities, both about the existence of units that might meet their needs and the existence of their housing. They have an obligation to analyze their policies and practices, foster inclusion, and eliminate discrimination. Section 504 has very similar regulations on this and are much more robust with regard to enforcement, but it does apply to Fair Housing Act covered properties as well. Next slide. Okay, so we're going to talk about tax credit developments. We've said they're already covered by Section 504 through Maryland policy. You can contact CDA, which is the Community Development Administration, that gives out tax credits if the provider fails to comply with Section 504. Developers are often responsive, I've found, because they have an interest. It's a very competitive process. So you can always contact the provider or contact DRM if you have questions. I will say most, if not all, tax credit deals in Maryland have federal state money. So even if it's not an 811 development, most of them have federal money in them to make it work financially in our state, and therefore they're covered by Section 504. Anyway, please go to the next slide. Okay, so I'm going to just skip through this quickly. Title II of the ADA does bring within its purview state and local operated housing. There is some housing in Maryland in certain jurisdictions that's run by cities or jurisdictions. So they are covered through the ADA. It kind of brings them within the purview of Section 504, requires programmatic and physical accessibility, equal opportunity, everything else Section 504 requires. Next slide. ADA also covers common areas in a development open to the public. So if the development has swimming pools, gyms, other things that are open to the public, the ADA brings those accommodations through their purview, and they must be made accessible. So it also covers services or programs to obtain housing, like an administrative office, the application process, inspections, certifications, accommodations, similar to Section 504. And the Fair Housing Act accommodations are not required if it poses a fundamental alteration or undue financial or administrative burden. Next slide. Okay, so here's what to do to enforce rights under the ADA, also under Section 504 in the Fair Housing Act. You can file a complaint with the Maryland Commission on Civil Rights. They must be filed within 6 months. You can file a complaint with HUD. Complaints are typically forwarded to MCCR, the Maryland Commission on Civil Rights. If they are Fair Housing Act complaints, HUD sometimes keeps them. If they are Section 5, UFAS, Section 504 complaints. DOJ, you can file a complaint with the Office of OCR, the Office of Civil Rights for the Department of Justice. They typically handle pattern and practice cases. Yeah, next slide. Okay, Maryland does have an accessibility code. It requires accessibility. It's interesting in that it requires accessibility when housing is renovated, which is unusual. It is enforced by local jurisdictions. If people have questions on that, I'm happy to take questions always on the accessibility code. Just to know that that does have minimum standards, I think is helpful. Next slide, sorry. Okay. All right, so here are some just review of what we're talking about with federally funded units. meaning public housing, HUD 811, etc., state and locally funded programs, and private market rate units. Okay, next slide. Okay, it's important to get to, if you don't know what the housing is in, that your client or person you're working with is in, it's important to think about this. Is the development federally subsidized? So how do you know? Clearly, most of the time, the rent will be set based on the individual's income. Okay, and let me just make sure I turn that off. Tenants are required to certify or present income yearly. Lease addendums from HUD are part of the lease typically. You can research deed restrictions, but you can also ask. So why is this important? Next slide. Okay. So market rate housing, of course, means housing where there is no requirement to keep rents affordable, no requirement to renew a lease, tenant pays for the modifications. In Maryland now has a requirement where every part of the state, the owner has to accept vouchers if the person otherwise meets the requirements. Next slide. Okay. State funded housing typically has a private owner, often a nonprofit or a nonprofit partner, funded pursuant to a competitive obligation under Maryland's rules and the IRS requirements. Landlords, if it's a tax credit development, the landlords must renew the lease except for good cause, and rents are set based on affordability requirements, not necessarily on the person's income. Okay, we can skip ahead there. Next slide. Okay, all right. So Chelsea's going to jump in and talk about person-centered housing.
Great, thanks, Luciene. Okay, so this part of the presentation is going to focus around in the event that you're working with somebody who needs a reasonable accommodation or modification, as well as individuals who have questions generally about what is allowed and what is not allowed. I would recommend using some of the tools that I'm about to go through to help the clients you're working with think through how it is that they can have that conversation about what modifications or accommodations they need and how to go through that process of making that request. So essentially, we have tools that we'll provide as a follow-up to this presentation. You do want to work with your client as you're going through tenant training with them on some of their preferences and needs. And in fact, I would recommend doing this before they even move into the building, simply because you want to make sure that the unit that they're looking at meets their needs before they even sign a lease. Individuals in our programs, they do have to conduct a move-in inspection as part of the process, but there's also the opportunity for an individual to go and conduct a tour. So if somebody is able to go to do a tour at the building, that's the ideal situation. Many property managers, particularly during the pandemic, have transitioned to doing video tours. So that's another option for individuals who might be either nervous about going in person or say they have a hard time getting out from the place that they're in right now, if they're in an institution or nursing facility. Definitely working with the person that you're supporting, making sure that they understand some of the distinctions between independent and permanent supportive housing versus shared housing. Obviously with the 811 and Weinberg programs, as well as the CCH program in Montgomery County, that falls under permanent supportive housing. And shared housing would be a circumstance in which an individual has a roommate. So that that's going to be a little bit different than the types of housing that our programs focus on. You do want to address any challenges, and that is essentially this process of working with a person about accommodations or modifications that they might need. That could be something that starts in the application process. Say they need an application in a different format, or they need more time to complete a certain part of the application. There is the ability for the person to make that request to the housing provider to be able to have some additional assistance with converting the format of the application. Say they need the ability to use the application with a screen reader. That is something the housing provider has to provide them with. So making a request like that is certainly something to really think about as you're going through the application process. Okay. So creating a person-centered housing plan. As I alluded to in the prior slide, the plan itself has to consider housing needs and resources. So this slide goes through all of those different needs, what they might be and what they might not be. So really focusing on, what personal resources does the tenant have? Do they have family support? What kind of income do they receive? All of this is information that has to be known prior to a person leasing up, and getting updated information from the individual is critical, particularly information about their personal circumstances. If they have family support in the area, or they have an individual that's their advocate, there is room for you to create a partnership with that person if the tenant feels that that is appropriate and necessary. It's very important to think about what transportation needs that person has. So if they are in a really rural area and they need to get to their doctors in, say, Baltimore City, that might be very challenging for them. So is it feasible for that person to move into that unit? Is there a way to assist them in getting some kind of additional transportation assistance? Or is there even a way to connect them to transit in Baltimore City to get to their doctors? What are their social networks like? Do they have in their new community an opportunity to engage with and meet other residents that could be either friends, or help them with acclimating to the new environment maybe that they've moved to? Okay. So we have a couple sample assessment tools, and if you've been attending the presentations that we've done prior, we've gone through my own front door. There are assessment tools in that document, so please refer to that. The link is included here. And then also in the case management manual on page 37, you'll get a copy of this presentation after. So you'll get links to, the links will be available through the PDF of this presentation. So this just goes through reasonable accommodations from before leasing occurs to the end of tenancy. You can see here, of course, that the process, reasonable accommodations have to be considered throughout each phase of this process. And I would say even prior to a person applying, they need to think about what kind of accommodations might be necessary. That's why it's so important to attend the any sort of meetings that are hosted by MPA when we're doing the lease ups, that when we have those meetings with other case managers, it's really critical to attend them, because that's when you can ask questions about things like this or bring it up. And in those meetings, Christina Bulliard from our team, she goes through a lot of information that's critical for the person to know, like utility assistance, some information we've already talked about in prior presentations. You also want to look at what is in the resident selection plan. Even if you are not helping somebody with leasing up a unit, you can ask us at any time to see a copy of a resident selection plan, and we have plenty on file that you can look through. A lot of the content in those plans is pretty standard, depending on the property management company. So take a look at those plans and see, could my client in the future, when they do lease up a unit, need an accommodation because maybe some sort of aspect of this plan is not going to work for them. Or maybe there's a question about, so say the person has a service animal, and maybe there's a certain aspect of the plan that it's unclear what kind of documentation they might need, or what the process is of getting the property aware of the service animal. Ask those questions before they even need to be asked, because it's good to know that information in advance. Okay, so this part of the presentation, just kind of talking about common barriers to accessing housing for people with disabilities. We've talked about this in some prior presentations in this workshop series, but this is why it's so important to stay in touch with your clients before you're even helping them with leasing up a unit. They might have documents that are expired that they've never had a copy of. We commonly have people who have expired photo IDs, state issued photo IDs, and they need that to lease up a unit. They might not know where a copy of their birth certificate is or their social security card. That's a document that both those documents are needed to lease up a unit. You want to make sure that their income information is updated. It's possible that they might not qualify for housing in a specific county because their income exceeds the required area median for that county. So you definitely need to know that before they go through the process of leasing. Make sure that the individual has updated information. Also, some individuals might have some issues with their credit report. It's good to know that before they even go through the leasing process, because if it's a situation where the person has a lot of medical debt, for instance, or they have some sort of discrepancy in information about their background, their financial background, that's something that you might be able to work with the property and see if they could accommodate for that person. A lot of people who have disabilities might have a lot of medical debt, and it would be worthwhile to at least have that conversation to see if the property can make an accommodation for that person. They might also have a criminal background record that could prevent them from leasing a unit at that property. That's where you would want to refer to some of the documents that are sent out by Christina as we're going through the leasing process to see what kinds of criminal background requirements the property has. And are any of the criminal activities that are listed in their background possibly linked to their disability? If there's a nexus of information in that background report that ties to the disability, then it would be appropriate to ask for an accommodation to see if the property can make an exception because that background has a disability related issue. And we've successfully had people make those requests and they've been able to move into units, but that's a conversation you want to make sure you have with the clients you're working with. So this slide just goes through accommodations that address access to housing. As I said, when you're going through the application process with an individual, you want to make sure that you know all of the information that you need to know to be able to help them be successful. That is information about their criminal background. That is information about their credit and financial background. This is a hard topic for people to talk about, and it's a very, very challenging. Sometimes it's embarrassing for people to talk about some of these things, But, you know, in order to assist a person in getting into housing, it's necessary to have these difficult conversations. But it is a good way to build your relationship with your client and really to help them understand that you're there to assist and you're there to support them with meeting some of their goals. Household members. So if somebody has to ask for a live-in aid, normally properties have a form that has to be completed where you indicate information about this live-in aid, and they have to do a criminal background check on the live-in aid as well. So make sure that you know, the person that I'm working with needs a live-in aid. So I need to help them with completing this form. And also ensuring as well that the live-in aid is identified well in advance of the leasing process. This is something that causes people to be held up in leasing often. And it is a barrier that we're really going to have to work with your client to help them get through, and also make sure that they're identifying the person that is really able to provide them with those supports that they need to live independently in the community. If they have a care attendant or service or emotional support animal, again, all of this information is something that will be requested by the property as they go through the leasing process. Service and emotional support animals are treated differently. They're not pets. So therefore, the individual is not going to be paying pet deposit fees on that service or emotional support animal. So sometimes if the property doesn't know that that's a service or emotional support animal, they're going to treat it as a pet. So make sure that you're telling them that information, so that way the person isn't expected to pay extra that they don't really need to pay. Searching for housing with a housing choice voucher. So, if somebody needs an accommodation on their search time, say they need extra time, that's something that can be requested. Number of bedrooms, if they need another bedroom for a live-in aid, for instance, that's another thing that you want to make sure that when you're going through that process, that those accommodations are requested. Okay. Again, reasonable accommodations in the application process. I've kind of gone over that a little bit in the last two slides, but these are some good examples. So providing applications in Braille, large print, or different formats. Allowing applications to be mailed or faxed, instead of having them sent via email, for instance. Also visiting the applicant's home to complete an application. So the housing provider, the property manager who's helping with the leasing process, they can, you can make that request and say, my client cannot leave the nursing facility. I'm going to need, you to help with the process of getting that lease signed. So we've had this request made many times in the past, and it's normally around an access issue, and also the ability to identify transportation to get to the property. So that is something that we've had done before. Also, if a person needs additional time to submit an application, we've been able to work with properties to be able to get people a little bit of extra time. Of course, all of these units have leasing deadlines, but if the property manager knows at the outset that this person's going to need more time, it's better to inform them as soon as possible. So that way they have a better idea of their timeline of when to accept an application or get the application from that participant. So finding UFAS or accessible units. This slide really is just to indicate to everyone who's participating today how you can go about that process. One of the things that we do as a department, as an agency, is request as many UFAS or accessible units as possible at a property, simply because we know that there's going to be a need. And as Luciene mentioned earlier, a lot of these units have features that any individual would benefit from having these features, like a expanded doorway. These kinds of things are helpful for anybody. and it doesn't really affect a person negatively if they don't need the features, right? So, and in addition, a person's needs might change over time. Perhaps their disability changes, or they need to move to having a wheelchair. They're going to need an expanded doorway, for instance. So there's different options here. And so, if that is something that the person you're working with needs, make sure that our team knows as soon as possible. So that way we can indicate to the property that, hey, this individual has certain accessibility needs. What units do you, in our program that we have, can we set aside for this person? Are there any UFAS units in the building? And part of that is something you can indicate through our waitlist system. So I encourage you to make sure you keep that updated. And so that way our team has a sense of what the person needs accessibility wise. So I mentioned this before, accommodations for credit issues. Again, that's something that can be requested in the application process. One thing I just wanted to point out, we do have individuals who apply for units in the program who might have perhaps unpaid utility bills from the past, or they owe back rent to prior landlord. If the property has documentation that they are on a repayment plan for those kinds of things, that is extremely helpful when you ask for an accommodation. So definitely if a person has a history of those things, that can be a barrier. So you need to know as soon as possible from the client you're working with that this is an issue that they might run into. So just make sure that you have the documentation, you have those difficult conversations before they go through the process of leasing up a unit. Reasonable accommodations and screening. These are a couple examples. I've referred to these in prior slides. So you can, go ahead and peruse that a little bit here. So yes, I mentioned all of these in prior slides. Accommodations for criminal background issues. I also mentioned this in a prior slide. These are some examples of those accommodations. So if the criminal background offense, or the offense that on their criminal background relates to narcotics use or drugs, completion of a drug treatment program might be something that property would be able to accept as part of that accommodation. If it's been a while since that offense occurred, that's something that they look at. And if the offense was not very recent, then it's safe to assume that individual has taken the steps that they need to take to be able to live safely in the community. Maybe they are able to look at some evidence from a healthcare professional indicating the person is stable, receiving treatment. All of that documentation helps in the process of requesting the accommodation. One thing I do want to mention, and many of you are aware of this because we mentioned this many, many times in presentations, federal housing assistance cannot be provided in the following two situations. If a person is on the lifetime sex offender registry, and if they were convicted of the production or sale of methamphetamine on federally assisted property. So those are the conditions that there cannot be an accommodation requested for those two conditions. Accommodations for criminal background issues, mentioning here the information on the screening process. So initially, I'm going to move my, an application might be refused based on a criminal history if everyone is asked about such convictions. So there was some HUD guidance that was released indicating that subsidized housing providers may not rely on arrest records to deny housing, terminate a subsidy, or evict. So this is important to note this information as you're going through the process. Private or non-subsidized housing providers must evaluate whether their criminal background policy has a disparate impact on any protected group. This is something that is certainly a case-by-case situation. And if the individual you're working with is impacted by their criminal background, then that is a conversation that you have to have with the person and also with the property provider. So it's definitely, you know, if it's something that is a concern or an issue that comes up in the process, you can, you know, bounce that issue off of us, and we're able to assist and kind of troubleshoot through the process of ensuring that the person has a fair access to housing as much as possible. Okay, service and assistance animals. Under the FHA, it is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or provides emotional support that alleviates one or more identified symptoms or effects of a person's disability. It can be any type of animal, and it can go anywhere where the tenant can go. The thing to keep in mind, though, is that this animal has to be within the tenant's control at all times. The housing provider may impose some reasonable requirements for health and safety reasons. Could be vaccinations, a requirement that the animal be leashed, or proper waste disposal. So if they don't have control of the animal and they're not taking care of the animal, and it's affecting the quality of life of others at the property, that is a concern, and again, warrants a conversation with the person that you're supporting. In addition, again, I mentioned this prior, pet deposits and additional fees or pet insurance not permitted for these kinds of animals. So here in this slide, talk a little bit about what the housing provider may ask about assistance animals. So again, I mentioned prior, exceptions to these rules are if the specific animal poses a direct threat to others on the premises. So the person has to have control of their animal. And a person with a disability who has an assistance or service animal, in my experience, at least in the properties that we've leased up with people with these types of animals, they do have control of them. But that is something that, you know, if there's issues that come up, the property manager is going to come to you asking questions about whether the individual can actually keep the animal. The other exception is if the animal would cause significant damage to the property of others, that cannot be eliminated with a reasonable accommodation. I think I mentioned prior, you know, an individual can request an additional bedroom as a reasonable accommodation. It is very helpful if that is indicated in our social serve waitlist system in advance, so we know that the person needs a 2-bedroom unit, and make sure that, again, that application is kept updated. So in the event the person is contacted for a housing opportunity, we are offering them the right opportunity. Commonly, people will request this for medical equipment and supplies. Say they have a Hoyer lift or some kind of large piece of equipment that they need to be independent in the community. That is something that they can request an additional bedroom for. Or if they have a live-in aid, as I mentioned previously. The other thing too is that the public housing authority or the housing provider, they may check to make sure the bedroom is being used as stated. So make sure that the individual is not simply requesting another bedroom for a person that they want to have stay over a couple nights a week, who is not providing them with any sort of assistance related to their disability. That's the key there. So this gives you a little bit more specific information about live-in aids and what a live-in aid is considered. So typically the live-in aid in the application process there has to be some kind of written verification from a healthcare provider that that live-in aid is needed. The aid's income and assets are not included when determining the rent price for the unit. So the property provider shouldn't be asking for that. And the live-in aid, it can be a family member if would not otherwise live in the unit. So that is a possibility that a person could request that a family member be their live-in aid. So this slide just goes through some more information about exception rents, utility allowances as a reasonable accommodation. So these are the circumstances under which a person might request this as a reasonable accommodation. I won't go into too much detail about this, but one of the things that I do want to point out is that a person could request a reasonable accommodation for their utility allowance if a client or family member uses substantially more electricity, possibly due to a disability related reason. So say they have a piece of medical equipment that uses a lot more electricity, that could be a reasonable accommodation request. So early termination of lease, this is allowed with a doctor's note that certifies the tenant's need to move. Say a person again has a change in their disability, perhaps they need a piece of medical equipment that will not fit within the unit that they're currently living in, or they need a 2-bedroom unit, they need a couple changes to their housing circumstances. Make sure that that person has documentation from their doctor on the letterhead that their doctor uses, a prescription pad and signed. So, you know, if a doctor prescribes, say something like a Hoyer lift, and the person's living in a 1-bedroom unit that's under 1,000 square feet, it's going to be hard to fit that in that unit. So make sure that the doctor is able to provide that documentation. The landlord may charge 2 months rent at market rate as an early termination fee. Make sure that the person you're working with knows that up front. It's important that they are aware of this information, because financially it could be a burden for them to pay something like that. If the person has a some sort of it might, I'm trying to read this. So there could also be as part of this process a conflict with the requirements of the Fair Housing Act. Make sure that you ask for a reasonable accommodation instead of a reasonable modification.
Chelsea, you want me to jump in there? And
yeah, that would be good.
Sure. So I think Maryland law there is in conflict with the Fair Housing Act in some cases. Real property 82122 does not specifically say that the person has to have a disability as covered by the Fair Housing Act. So I think under some circumstances, someone might qualify for 8212 if they had, you know, back surgery and needed an accessible unit for the next several months, but were expected to make a full recovery, for example. I make it a policy to always ask for the fee to be waived, and I ask for it under the Fair Housing Act, and I wait for the landlord to come back and make the argument that they can charge 2 months rent at market rate. I would say we have been very successful at DRM with not having our clients not have to pay that 2 months market rent. You may need to go to a lawyer to actually help facilitate that process. But I think that 2 months market rate really arguably for many of our clients would be in violation of the Fair Housing Act, which says you can't charge for giving a reasonable accommodation.
interesting that those two things conflict, but that's good to know. Thanks for hopping in there. Okay. So threatening behavior. This is important to also go over with the person that you're supporting. The individual, now the landlord is allowed to, essentially evaluate if an individual has some kind of direct or objective evidence of a threat. This could be an issue and could also lead to a lease violation. Tenants can request a reasonable accommodation to have equal access. Maybe they need a little bit more support or treatment for the issue that is causing the threatening behavior. But a landlord doesn't have to grant an accommodation if the person poses a direct threat to the community. We have had people, who have been, who've received lease violations for this issue. And we've also had people who unfortunately received notices to vacate for this issue. So this is something that if you know the person you're supporting has these concerns, make sure that that is, a conversation that you have with them, saying that, if they pose a threat to the community, if they pose some kind of risk, they could lose out on their housing. So it's important that that kind of treatment is offered to the person, and hopefully that they're able to get counseling and support, so they do not have this issue when they live in their unit. So inability to
Could
care.
I just jump in there for a sec?
Oh,
I'm
yeah,
so sorry,
sure.
but yeah,
No,
for that
okay.
previous one. So I think it's really important to say that this is where you can be a good advocate for your the person you're supporting, because often property managers don't have extensive knowledge about individuals' disabilities or when they're posing a threat. So you will frequently see things where they're just kind of fed up with having to deal with someone, and that's not what the law says. You can't evict someone for that. So just because someone has schizophrenia and they act odd does not mean that they are dangerous, or if they have had behavior that was concerning but have obtained treatment or are now in anger management classes or something, there may be no direct threat. So if it can be mitigated, the direct threat exemption does not apply. They cannot be evicted for that. And it has to be individualized. So, once I had a case with someone who did have an issue where she had bipolar, she became ill, she was disturbing her neighbors pursuant to a delusion she was having, and obtained treatment, was doing fine. The landlord proceeded with eviction with the idea that, well, people with bipolar always stop taking their medication, and this is just going to happen again. And that's not what the law says. It needs to be an individualized determination. So talking to the person's therapist, talking to people who provide them treatment, getting good letters from them is key here to saving people's tenancy.
Yeah, I agree. And this next slide as well, same kind of situation, right? So a property provider cannot make that determination that a person's unable to care for themselves or the unit. And they might, and sometimes they do that, or they try to say that an individual, their disability status is such that they're not going to be able to live independently in the community. What we say to property providers who come with those assumptions about an individual is that they are not medical professionals. They cannot make that determination. And it's a violation of that person's rights if the property is trying to prevent that individual from leasing a unit simply because they have different medical needs. The property provider can't have addenda or emergency contact forms with the application that authorizes a family member, friend to end the lease or remove the individual from the unit. It could be considered disparate treatment based on disability. So, you know, if there are those kinds of additional forms, and we catch these things during the application process when we're working with a new property, we look over all of their forms and make sure that the forms don't have any sort of discriminating information, you know, that the individual is being required to provide information about, detailed information about like what kinds of supports they need. That's not appropriate. They don't need to know that information. It's something that we've had happen, unfortunately. So that's something to kind of keep on your radar as you're going through the process with the person that you're working with. Let me move my, so reasonable accommodations to prevent an eviction. Landlords are able to end a lease if the tenant has breached their duties under the lease. These are, it's a very brief list of what lease violations might include. And all of this information is usually also in the tenant selection plan for the property, the resident selection plan that is provided in the leasing process. So if a person has unauthorized occupants, people who are staying in the unit for more than 14 consecutive days, if they have a situation where they're not paying their rent, that's another lease violation. If there is health and safety concerns, criminal activity going on, it could be that the person has guests that come by who are committing criminal activities. That could be a lease violation. Typically it is, and we've had people who have been, you know, received a notice to vacate based on criminal activities going on around their unit, guests that they've had and not themselves. Again, if the person has threatening behavior, that could be a lease violation. So this kind of goes through information on how to make a reasonable accommodation request. As Luciene referred to, it has to be linked to the disability to the need. So make sure that that link is clear in the request that you make of the property. This just goes through when and who can make those requests. Any person employed by the housing provider can receive a reasonable accommodation request. Could be the property manager, could be maintenance person, or other individuals. It's really important when you're going through this process, even though the requests do not have to be submitted in writing, we highly recommend doing it because you can track when the request was submitted and if it was not addressed. So if you have a letter sent in that it's dated, has all the relevant information, that makes a huge difference in getting that request addressed. And if it's not addressed, then you know how to follow up, or you know when to indicate that this has gone unaddressed for 30 days or more. This is an issue. A person with a disability can make the request, but a healthcare provider or family or friend can do that as well. So that's allowed, and the property doesn't have to, you know, they don't have to say, well, we're not going to honor this request because a family or friend made the request. That's another important piece of information. As I mentioned, the request can be verbal, but we encourage a letter. The letter should include the statement that a person has a disability, what accommodation is needed, as specific as you possibly can get, and how it's tied to the disability. This is a sample letter, and we can provide after this presentation a template, but there's also templates in the My Own Front Door manual that you can refer to and use. So happy to help out if you have questions or need assistance with writing this request. So things that the housing provider might request from you after receiving the letter. They might want to have information from a healthcare professional, documentation from a healthcare professional that the accommodation is needed due to the disability, unless it's obvious. So if the person is obviously blind or obviously hearing impaired, then they're not permitted to make those requests, or you don't have to provide that additional documentation. It's makes it a little bit easier and more streamlined to get those documents though from the healthcare professional. They can't require the requester to use a specific form, but properties sometimes do. You know, we have had many individuals who've simply submitted letters using the template in the prior slide, and that has sufficed. So something that, you know, you can work with the person that you're supporting and kind of help them with what makes the most sense for them. So this is essentially what happens after the request is received. The response that the property provides, that should have a time frame included for providing the accommodation. They might propose an alternative strategy. That's where the accommodation becomes a conversation. So make sure that you stay in touch with the housing provider and the person that you're supporting and have that conversation of what might work best for them if they think that they're not able to honor the initial accommodation request. And there's some information here as to why an accommodation might be denied. There has to be a reason provided, and there has to be a dialogue again to discuss other possible solutions. Okay. So this part of the presentation, I wanted to, let me see what time we have here. Okay. I wanted to have people go into breakout rooms to discuss some scenarios. However, I am not seeing, let me see. I believe that looks like we have a couple questions.
I think we answered them, right? There was a question about, can independent living requirements be applied to a person with Alzheimer's or dementia? And I think, you know, the answer to that is that if the person can meet the requirements of tenancy with the supports that they have, then they can't be denied housing for that reason, simply because I think providers can ask, you know, how can you meet the requirements of tenancy? As long as they're asking everybody that applies, they can ask a person with disability that same thing.
All right, very good. I am not seeing the ability to do breakout rooms for some reason, even though I had initially indicated that I wanted to do that. Let me see if I'm able to. I don't believe that I'm able to do that. So typically when we do this in person, we have individuals assigned to be able to you know, discuss in small groups how they would handle different scenarios. So I do have some work groups and some scenarios I want to indicate. Let me stop sharing for 1 second here. So I'm going to go ahead and share these scenarios with the group, and I want to, for people who are logged in and who are in the logged in through the computer, So unfortunately, if you're joining us by phone, you will not be able to do this since you don't have access to the chat. But I will run through these scenarios briefly and try to see if people can give me some responses in the chat is what I will ask for. So, and I'll pop this, you download this and put this in the chat so you all can read along if that's easier. All right, one moment here. Let's see. Sorry, this is gonna take me 1 second. Okay. All right, so for those of you who want to follow along at home, I put the document in the chat so you can just click on that document and download it, but I will read these scenarios as well out loud.
You want me to share it? I think I can share it.
Oh, okay. Yeah.
Let me see. Did that work?
Yep.
Okay.
So we can go to the,
First one.
Yeah. Okay.
There we go. Okay.
Very good. So scenario number 1, Susan has been living in a nursing facility for the last 3 years. She was placed in the facility after being hospitalized due to a car accident. Due to her injuries, Susan lost her job and was not able to continue paying her rent and utility payments at her apartment. The injury also resulted in impairment of Susan's memory. She did not remember that she had been renting an apartment and consequently did not inform her landlord of her injury and need to terminate her lease. She also did not turn off her utilities and is approximately $400 in arrears with the utility company. Susan is ready to transition from the nursing facility and has applied for an apartment through the HUD 811 Project Rental Assistance Program. However, Susan's credit and rental history have resulted in denial of her application for the apartment. So my question for the group is, can Susan request a reasonable accommodation for these circumstances? Perhaps what would that reasonable accommodation, what kinds of information, if she is able to request it, would need to be provided in that accommodation request? And you can pop your answers to this in the chat and I'll just kind of read off on what people are responding with.
I don't know if I need to stop sharing to see the chat.
I think if you click on chat, it should pop up as an extra little box. It's kind of hard to see when you're sharing your screen. If you go to the top of your screen, it should give you
I
the
see.
option.
Yeah.
You see it? Yeah.
Yeah. Okay.
Okay, so Monica says, yes, due to her injury, she should provide documentation from her physical and mental health providers. Okay. Any other responses to this scenario? Make sure to put your information in the chat. Okay, Abiola says, a reasonable accommodation letter regarding the hospitalization and institutionalization for the past 3 years and need for MDOD to overlook the history related to the former apartment plus supporting documentation from the hospital. What about the utility company? What kinds of information might the property want to see regarding her arrears that she is in? Do you think they want to see information about that? Okay. Documentation from the nursing home as well, that makes sense, and efforts to settle the debt. Yep. So that seeing that she is on a repayment plan for those arrears is critical, and will certainly help her in the leasing process.
She
Injury.
owes so much that it's just not possible to settle it. She could consider bankruptcy. And if that was due to disability, that should be overlooked as well. I think I think the guidance now from HUD says that federally subsidized providers can't hold bankruptcy against someone.
There's also AR indicated injury was the result of unpaid utility bills. Would be information the property might want to see. Okay, great. So I'll go ahead and move on to the second scenario here. So if you're following along, just kind of scroll down to scenario number 2. Oh, I have another comment here from Monica. A letter and documentation from all medical providers can be sent and copies sent. There are community resources that would assist with unpaid bills. So that's a good point, Monica. The critical medical needs program is underutilized program, but one that we've sent out information about often to our MPA case management subcommittee group that Christina Bolliard from our department oversees. And that is a program that I encourage you all to work with your clients and see if that is a resource that they can apply for and receive, because it helps with paying past due utility bills. And it also assists people who have medical needs who they need to ensure their services are not cut off. Abiola made a comment, good to know regarding the bankruptcy, but how and who could / would have applied for that for Susan?
Oh, legal services can assist with bankruptcies.
Okay.
In some cases. Yeah.
Good to know. All right, so the next scenario I want to go through. Alex was arrested 2 years ago for assaulting his brother and for possession of cocaine. The court determined that Alex was in need of extensive mental health services and placed him in a mental health court diversion program. This program provided residential treatment, substance abuse treatment, counseling, and anger management classes. It also provided psychiatric services for medication management. Alex has successfully completed the program and is ready to transition to renting his own place. He has been employed for the last 9 months and has applied to rent a tax credit apartment. His application for the apartment was denied due to his criminal background. Can the case manager supporting Alex request a reasonable accommodation or modification? Which would it be? And what would be included in that request? You can just pop your answers in the chat. And if you also want to raise your hand and discuss your answer, I can unmute you as well. Abiola says the reasonable accommodation letter should include proof of successful completion of a drug treatment program and hospitalization, as well as proof of disability from the doctors who treated him. Okay. Anybody else have comments on that scenario? All right, I think that one's pretty straightforward. Okay, so moving along to scenario number 3. Roger has a physical disability, which results in the need for medical equipment. He uses a power wheelchair and also has a manual wheelchair, which he uses as a backup and when he travels to Florida to visit his mother. Roger also needs to use adult diapers and has physical therapy equipment, including bolsters and a wedge, which he uses to maintain as much mobility as possible. Roger has been looking for an apartment that meets his needs, but cannot find anything that is wheelchair accessible. Could Roger request reasonable accommodation or modification, and/or what kinds of information do you think the property provider might need to know in order to ensure that he gets a unit that meets his needs, or MDOD? Okay. And you can indicate any information in the chat regarding this scenario. One thing I do want to mention about this scenario is, again, you know, if Roger qualifies for the 811 or Weinberg Apartments program, make sure that when you're going through the application process, you're indicating what needs he has related to his physical disability. We need to know whether or not he needs, you know, a raised, say like a ramp type entry to be able to get into a unit. We need to know if he needs to live in an elevator building, which for Roger, it sounds like an elevator building would be most appropriate. Not all of our buildings are equipped with elevators. Some are garden style apartments, meaning that they have stairs that go from one level to another. So that's information that we need to know, and we're better able to identify units that are appropriate if we know that information before the leasing process even happens. Abiola says his specific reasonable accommodation should have been noted in his initial application and reiterated throughout the process and the visit to the property. I agree. And you know, he might also need a second bedroom. It sounds like he has additional medical equipment. Make sure that we are aware that he needs a second bedroom in order to put his medical equipment in. And again, that's a conversation that you want to make sure you have with Roger before he goes through the leasing process. Yeah, so Monica said exactly what I just said. Roger should be able to request an additional room for his medical equipment. I 100% agree. And for him, it sounds like it would be appropriate. Okay, so we'll move along to scenario 4. Jeff has a disability which requires him to take medication to stabilize his mood and help with his anxiety. He also takes medication to prevent seizures. Jeff has 3 animals that are very important to him. He has 2 dogs that help with his anxiety and a snake that alerts him before he has a seizure. Jeff experienced homelessness during the past year, but has always had his animals with him. Jeff has a new job and will receive short-term rental assistance from the shelter where he was staying from time to time. Jeff applied for an apartment at a complex that allows pets. The property manager told Jeff that they only allow 1 dog and do not allow people to have snakes because they intimidate neighbors. Can the property make a request like that? Or is that an inappropriate request for them to make? And what does Jeff need to do to be able to, you know, and also as a case manager, what kinds of support can you provide Jeff in order to ensure that he has a building or a unit that meets his needs? Yep, Abiola says, no, the animals are not pets. Exactly, they're not pets. Agreed. And a property can't, oh, go ahead.
There is new guidance from HUD under the last administration. So perhaps it will get changed, having to do with common household pets that seems to exclude snakes, reptiles, and other non-common pets. That doesn't mean to say that he could never have a snake, and he does seem to have you know, a medical need for this snake if it alerts him when he has a seizure. And there is actually some medical studies indicating that snakes have been able to alert people when they have a seizure by their behavior. So in that case, if his medical professionals would write a letter indicating that the snake does perform a specific task for him, they think the provider would have to allow it. In the past, we've given the advice that that he could have the snake as an emotional support animal so long as it was verified, but HUD has changed their advice on that. Yes, so Monica's saying yes, exactly. He can provide documentation, and I think if he has documentation similarly that he needs both dogs, then both dogs should be permitted so long as it was permitted by local zoning or local ordinance. Sometimes there are requirements. You can't have more than, I don't know what it is. I think in Baltimore City it's something like 4 dogs and 9 cats or something like that. So if they come and show up with 10 cats in a 1-bedroom, I think the landlord would have a pretty good argument that that was not reasonable.
Right. All right, so I will quickly move along to the last 2 scenarios here. Scenario number 5, Shanika lives in a tax credit development. She has a physical disability and uses a wheelchair for mobility. Shanika has a van with a wheelchair lift. She often has trouble finding a space in the apartment parking lot because she needs an access lane for her lift, and because the designated handicap parking spots are often full. She has heard from other tenants that a reserved parking spot in this development costs $75 per month. So my question here for you all is, can the property charge Shanika the $75 per month for getting the reserved parking spot in spite of the fact that she has a disability and she needs access to a spot? Can she request a spot be made available to her, and what kind of request is she going to be making in order to get that spot? Would it be an accommodation or a modification request? Abiola says an RA letter to waive the $75 a month for a reserved parking spot. Okay.
Yep. I think that's exactly right.
Mm-hmm.
That they would have to waive that as an accommodation to her disability.
Yeah, and the fact that the designated handicap parking spots are often full, makes me wonder, do they actually have enough available for people? I've gotten this call before from individuals who are not living in 811 units who don't have a handicap spot and they need one, and the properties that they're living at have refused to provide them. So that is not acceptable. If they need the spot, they need the spot. Okay. Scenario number 6, Marta has an adult son living with her who has autism and other mental disabilities. As her son has gotten older, he has had trouble controlling his outbursts and is sometimes loud at night, prompting complaints from neighbors. Marta is convinced that a first-floor unit that faces the back of the complex where there are woods and it is generally quieter would be helpful to her son's stability, but first-floor units in that area of the complex rent for $175 more per month. In addition, there is a waiting list for these units, and the development's policy is that they typically accept 1 new tenant for every existing tenant that transfers. Also consider, while Marta and her family are waiting to transfer, her son has an outburst and yells at the children in the building, scaring them. Marta receives a notice of eviction, and the letter indicates her request to transfer is canceled. Can the property do something like this? Is Marta able to ask for a reasonable accommodation or modification to have a unit on the first floor? What kind, would it be a modification or would it be accommodation? Oh, so I did have one comment here. Most properties do not have enough handicap parking units. I agree with that. Okay. Luciene said here, Maryland's accessibility code provides for the number of required handicap parking spaces depends on the number of units in the building and complex. Does anyone have comments on this scenario? What would Marta do? Are they allowed to evict her because of her son's outburst and yelling at children in the building? Anybody? Marta should be able to ask for an RA for her son. Okay, what would be included in that RA in the reasonable accommodation request? So I think the property would, you know, if his autism and his mental disabilities are the reason why he's having these outbursts, but if he had a different type of unit, it could be better controlled, then yes, the property should be able to, you know, the request to transfer should be something that they're able to consider. And in addition to that, could they actually send her just a notice to be evicted over this one thing? Is there another step that they have to do before they simply tell her we're evicting you? Monica says to move to the back by the woods without paying extra money. Yeah. I think Marta should go to landlord tenant court and fight the eviction as part of her son's disabilities. They have to file in court. Okay.
So I do think that a landlord can, you know, terminate someone's lease, right? Write them a letter and say, we're going to end your lease because you violated the lease. While having an outburst and yelling at children in the building without knowing more, it's hard to know if that violates someone's lease. I think it legitimately it could, but it seems like this family has an excellent argument that they should be accommodated with a reasonable accommodation. Plus, first, because she believes he would not pose a direct threat if he was in the back of the building. So I think she should definitely proceed with a reasonable accommodation request. She certainly needs to talk to her son's medical providers and disability services providers to ensure that they agree with her hunch that it would be less chaotic and better for controlling his outbursts and his being loud at night. So if he's in the back. With regard to the $175, that's interesting to me because I think it would depend on, you know, if it was a little tiny building that had 4 apartments, possibly not, because that might end up being a lot of money over time for a landlord that had to, for example, pay a mortgage. But for a big complex, it probably is not a lot. I don't know that one's a slam dunk at $175 a month. HUD clearly has said that landlords have to absorb some costs of providing reasonable accommodations. I think it would depend on what a court thought. And certainly if they have a voucher, they should go back to the housing authority and ask for an exception rent. Yeah, I definitely, so Abiela is saying, is there a fine line between frightening and threatening? I mean, I guess it's all in the eyes of the beholder, right? You know, it's hard to know, and it's hard to know what judge you're going to get to. So I always try, when we're representing people, we try not to jump to court because there's far less control over this situation. You're putting it in someone else's hands. When negotiating, you can probably resolve the issue. If he hasn't ever acted on his outbursts and he's just been loud, and there's good evidence that he he's able to control his outbursts and is quieter when he's in a more quiet environment, I really think that that's a successful way to go.
Great. All right, so I'm going to go ahead and launch our post test. So for those of you who are logged in and following on the computer, I just went ahead and launched the post test. So please respond to the best of your ability. I do have a hand raised. Who has their hand raised? Maybe not. I can't seem to locate the person with their hand raised. So you all should be able to see the poll. So go ahead and send in your responses and we'll go over them live. You guys see the poll?
Yes,
Okay, you
I can.
Yeah. All right. Keep sending them in. All right, I'm gonna give you guys 10 more seconds to send in your responses. All right, I am gonna end the poll now and share the results. Okay, so the first question, are all landlords required to provide reasonable accommodations based on disability? Yes, they are. We have 64% that said yes and 36% that said no. It cannot, as Luciene and I talked about, the undue financial burden is one of the issues that might prevent granting a reasonable accommodation request, but they are required to have a conversation as to what other alternatives might be possible for them to be able to help the person, accommodate the person in some way.
And I'll just jump in that there are landlords that don't have to, that aren't subject to the Fair Housing Act, Section 504, and that would be landlords in 4 or fewer units where there's an owner occupied unit, single family units that are rented without the use of a real estate broker, real estate agent, or advertising. Units that are limited to membership of a private, religious, or charitable organization, pretty unusual. Yes. Well, and then there are units that they're subject to the Fair Housing Act, but they, for example, the accessibility requirements might not apply if, for example, it was built before 1991 when the regulations went into effect. It's only, the physical accessibility only applies to housing built for first occupancy.
Great. Yeah, so the exceptions were discussed in some of the initial slides that Luciene went through. And again, these slides will be sent out after the presentation. So I encourage you to take a look at the slides. If you do have a situation where you're working with somebody that their reasonable accommodation request is denied, see if one of the exceptions might be the reason why the denial occurred. All right, so the next question, do reasonable accommodation requests need to be submitted in writing? I had 64% say yes, 36% say no. They do not need to be submitted in writing, but they can be verbal, but it is very important to the best of your ability to try to submit them in writing, because it's good to have that paper trail, especially when you're making sure that the person is getting their needs met. The third question here, do service animals need to complete a certification course to be approved? 73% said yes, and 27% said no. And we talked a little bit more about service animals, and we thumb through my slides so I can give you guys the exact language there. So the housing providers, they might impose some reasonable requirements for health and safety reasons like vaccinations, requirements that the animal be leashed, and proper waste disposal. But the person does have to have control of the animal, but there's not, they don't have to provide documentation that, you know, the animal has gone through some kind of certification course. You know, and sometimes people, the animal that they're working with, you know, as long as it's within the person's control, and that the animal is also designated as a service or assistance animal, then the person is allowed to have that animal with them to provide the services that they need to provide.
It's a self-designation. It doesn't have to be designated by any agency. So the only thing the landlord can ask is this animal specifically trained to perform a disability-related task for you? And if so, what task do they provide? That's it.
Yep. Question number 4, can someone other than the person with a disability make the request for a reasonable accommodation or modification? 64% said yes, 36% said no. So it is yes. Somebody who is a friend, member of the family, a case manager can make these requests on behalf of the person with a disability as well. Is there a time frame for when the reasonable accommodation request can be made? 45% said yes, 55% said no. So there's not a time frame. If a person needs an accommodation, you know, at any time during either the application process or afterwards, say that they need their case manager included on all communications that are sent out to them. We've had that kind of request before. The property might send them a letter directly and say, you know, hey, tenant XYZ, this is, you know, what changes we're bringing into the community. Some people might request that they want their case manager included on those communications to be like a go-between person. And that's okay. And that might happen at any point in the tenancy for an individual. Does a reasonable accommodation request need to be made to the property manager? 82% said yes, and 18% said no. It does not need to be made to the property manager. It can be also made to maintenance staff or other individuals who the person might interact with in the course of their tenancy and address the letter to. I do recommend that it be made to the property manager because they're going to be the ones that are going to be working on that request. So making a request to a maintenance person will likely not get addressed because they're not doing the administrative work in the building. So it's just something to keep in mind. Are tenants required to pay for reasonable modifications made to common areas such as laundry rooms or community kitchens? 9% said yes, and 91% said no. As Luciene said prior, it depends, right? So it depends the kind of funding that the building has. For the 811 and Weinberg Apartments program, reasonable modifications that are made, those are things that the property provider, as long as it doesn't create an undue financial burden, they have to, you know, honor those requests. And Luciene had mentioned prior as well that the marketability of the unit, sometimes, you know, property provider might go back to the person and say, you need to pay to get this converted back to what it was prior. But if it doesn't impact the marketability of the unit, then they don't have to do that. I don't know, Luciene, if you wanted to jump in on that.
Yeah, I mean, I think if it's I think you said it exactly right. Yeah, and if it's a common area used by everyone, then the landlord has to maintain it after the 10 days. We've had that happen where it was an older building in Montgomery County that had steps out front. It had not been renovated. It did not have federal money in it. And the tenant paid to have a ramp put in, which cost a good amount of money, but he didn't want to move. Yeah,
right.
That does happen.
The last question here, is there a restriction on the kinds of animals that can be emotional support animals? 45% of you said yes, 55% said no. So I don't know if my slides may have gone over this or not, but service animals, by definition, at least I don't believe that this has changed in the last year or so. They are designated as dogs, but emotional support animals, there's not a restriction on that. It could be, I mean, commonly we've had people who've had, say, cats as an emotional support animal or a dog. It just, kind of depends. It's uncommon for us to have people who have different kinds of animals that they have as an emotional support animal, but it has happened. So that's something
This
to
is
keep
the
in mind.
new guidance from HUD, which I'm wondering if it'll get changed. But
Yeah,
under the last administration, the guidance said there is a restriction on animals that can be, they call them all assistance animals now. HUD does not make a distinction.
oh,
They say that needs to be commonly kept domesticated animals, and it appears
Gotcha.
to specifically exempt, exotic animals, reptiles, etc. I think, HUD has clearly said over the years that an assistance animal can go with the individual and into any part of the building. So I think there were lots of conflicts over this, and it may get changed. Since there are no lions, no lions.
No lions. All right.
We'll send you the new emotional or assistance animal
Guidance. Yeah.
I think it came out in 2019.
Okay, gotcha. All right, so that is all we have for today. I'm gonna stop sharing the poll here. So thank you, Luciene, for joining us and presenting on this topic with me today. And thank you everyone who's attended all of the workshops in this series. For those of you who have completed all of the workshops required in this series, you will receive a certificate. I will email that out to you. If you want to have a physical copy, I can make that happen. You just have to give me your mailing address so I know where to send it. And those, I would say expect that in the next couple of weeks. I will likely work on that and make sure I get that out to you. And thank you everyone for your time. Feel free to send us any questions that you might have. You can shoot me an email if you have a question about anything that we went over today during the presentation. And have a good rest of your Wednesday.
Everybody.
Thanks everyone. Take care.